We all hope nothing goes wrong with our contracts, but Nicola Lynch will be asking Clerk Sargent how to manage it if we have to terminate our contracts.
So how important is it to plan for the worst when drafting a contract?
It's absolutely imperative if you're the in-house lawyer to make sure that you've covered off what might go wrong, because what's certain is when it does go wrong, they're going to come to you and ask what to do about it.
And how does the law allow for termination?
You can just rely on your rights at law, can't you? Because any contract can be terminated at law if the other side breaches a condition. The difficulty on that is, of course, that you've got to know what's a condition in your contract, and that can be difficult to spot. And we know it's difficult to spot because there's absolutely stack loads of case law on this stuff about when you can terminate a contract. And the reason that there's so much case law is because, of course, it's uncertain, because you're always arguing about whether somebody's committed a repudiatory breach or not, or whether they've done something that's sufficiently serious that you're allowed to terminate the contract. And that's all got touch and feel about it, hasn't it? So, and touch and feel means risk when it's gone wrong.
So why should contracts include a termination clause?
Well, it's exactly to answer that point that we were just looking at. The contract, you can put whatever you like into the contract. There's an area that you can deal with at law, but it's risky. So you can provide in the contract for what you want, what you need, to determine when you want to, when you think something sufficiently bad has happened.
So what really needs to go into a termination clause?
Well, the primary thing you're looking for is you want to put in as much certainty to answer that point as you can. So you know what you think will be your termination events, so you've just got to write them down, but with clarity so that people understand what you mean. And on that, of course, in these clauses, you will see, I can terminate for material breach, you sort of sweeper upper at the end. And again, even when you're doing that, you can look at, where am I setting the bar here? What do I mean by material breach? For example, missing a payment by this many days, that would be a material breach in the context of this contract. So you get the freedom to put all of that in.
So could you tell me a little bit more about the consequences of an early termination?
You've just got to think about and plan for what you're going to need back. You also want to think about, and this is very pertinent, we've seen people get this badly wrong, is how much time is it going to take me to get somebody else in to do what they're doing for me? Because obviously I can terminate them now, but I need somebody else to do that instead. So you've got to plan for that as well.
I know a lot of in-house lawyers will be interested in damages. How do you deal with damages in a termination clause?
You can try and rely on your rights at law, that you're terminating contracts under law, and you can go after your loss of profits claims, and those are always, very big numbers. But you've got to remember that when you're going after loss of profits, your view of what your lost profits are and the other side's view are going to be very, very different. And that means there's uncertainty there as well, and you've got to go to court and get somebody assess it for you. You've got to get a judge, you probably need expert accountants, and it's all expensive, and it takes a period of time. So you can try and deal with that in your contract by setting out in the contract what you think the formula is for what you should get back if certain events happen. You can provide for it. You can say specifically. You can put in liquidated damages clauses. And again, worth bearing in mind, you say that to an in-house lawyer, liquidated damages, they'll be thinking about penalties. The courts have been really narrowing those recently in commercial contracts, so much less risk around those. So, the opportunity to use them is much wider now than it might have been, say, 10 years ago.
And what about using a termination clause once drafted?
You always end up again back with these questions from when we were at law school, really, isn't it? About whether you should be terminating contracts at law or whether you should be terminating contracts under the termination clauses that you've written. And that's a really complex area now because of some cases that come out of the House of Lords and Court of Appeal over the last few years. And the courts have got us to a place where you sort of have to make a selection. You can terminate at law, but we know that if we terminate at law, you've got some of that risk and challenge around what you've done. If you go after the contract clause, you've got a lot more certainty around that you're entitled to terminate, but you might be going after a lesser number. And you've got to take a view of which one do I want. But of course, actually then, as the in-house law, you've got to look at whether there's an option to try and get both. And there is, under the cases, there is actually still an opportunity to use both if you go in the alternative. You sort of try and terminate at law first, knowing that's a bit risky. And then to cover your risk, you terminate in the alternative under the contract. And if you get, if you have to come back and rely on that, you're going to get something, you're safe. But you try and get this as well, just in case. And then the second area that you've got to check that you've got covered off is you have a period of thinking time. The courts allow you that. Of course, you've got to have, something's happened. What am I going to do about it? But you've got to be wary that the courts time this thinking time. There is a limit to it. And you've just got to be wary that you don't go outside the time period they're going to allow you in the context of your contract and then end up having the contract affirmed by what you've done by not terminating, and then you've lost the opportunity. And of course, if you then try and terminate, you can get into trouble. So you've got to make sure you go within what's a reasonable period.